the legislative branch. Section 29. Legislative power vested in General Assembly. The legislative power shall be vested in a House of Representatives and a Senate, which, together, shall be styled the General Assembly of the Commonwealth of Kentucky. This is essentially the same provision as its equivalent in the Third Constitution and much the same as those found in the First and Second Constitutions. The relatively few published appellate court cases dealing with this section mostly concern allegations of legislative power being invalidly exercised, usurped, or delegated. Section 30. Term of office of senators and representatives. Members of the House of Representatives and Senators shall be elected at the general election in even-numbered years, for terms of 4 years for senators and 2 years for members of the House of Representatives. The term of office of representatives and senators shall begin upon the first day of January of the year succeeding their election. Section 31. Time of election and term of office of senators and representatives. At the general election to be held in November 1984, and every 2 years thereafter, there shall be elected for 4 years 1 senator in each senatorial district in which the term of the predecessor in office will then expire, and in every representative district 1 representative for 2 years. Voters approved amendments to these sections in 1979, which changed legislative elections from odd to even-numbered years. The framers of the current Constitution had specified odd-year legislative elections in order to avoid having those elections regulated by the federal government, as was provided in the Federal Elections Bill of 1890, not enacted into law. The election of legislators in even-numbered years permits newly elected individuals to gain a year's experience by working on interim committees prior to the convening of the legislature. Representatives under the first 2 constitutions were elected for 1-year terms, and for 2-year terms under the Third Constitution. Senators have had 4-year terms under each constitution. Section 30 has not been the subject of published adjudication. The Kentucky Court of Appeals cited Section 31 as one of the reasons for not certifying a district election for the state Senate following a redistricting statute where such an election would have increased the number of senators beyond the maximum provided in the Constitution, in Angeles v. Land, 1963.
Section 32. Qualifications of senators and representatives. No person shall be a representative who, at the time of his election, is not a citizen of Kentucky, has not attained the age of 24 years, and who has not resided in this state 2 years next preceding his election, and the last year thereof in the county, town or city for which he may be chosen. No person shall be a senator who, at the time of his election, is not a citizen of Kentucky, has not attained the age of 30 years, and has not resided in this state 6 years next preceding his election, and the last year thereof in the district for which he may be chosen. The age requirement for representatives has been the same in each of the Commonwealth's 4 constitutions. The residence requirement has also been the same except that the first constitution specified 6 months residence in the county of selection. The age and residence requirements of senators are the same as those found in the Third Constitution. The Kentucky Court of Appeals has ruled that Section 32 requires a candidate for the House of Representatives to have lived in the legislative district that he or she wishes to represent for 1 year preceding election, in Grants v. Grumman, 1957. This requirement applies even if the district was created less than a year preceding the election, in McConnell v. Marshall, 1971. Section 33. Senatorial and Representative Districts. The first General Assembly after the adoption of this Constitution shall divide the state into 38 senatorial districts, and 100 representative districts, as nearly equal in population as may be without dividing any county, except where a county may include more than 1 district, which district shall constitute the senatorial and representative districts for 10 years. Not more than 2 counties shall be joined together to form a representative district, provided, in doing so the principle requiring every district to be as nearly equal in population as may be shall not be violated. At the expiration of that time, the General Assembly shall then, and every 10 years thereafter, redistrict the state according to this rule, and for the purposes expressed in this section. If, in making said districts, inequality of population should be unavoidable, any advantage resulting therefrom shall be given to districts having the largest territory. No part of a county shall be added to another county to make a district, and the counties forming a district shall be contiguous. Unequal apportionment of legislative districts favoring the Whig Party represented one of the grievances that produced the Constitution of 1850, but delegates to the 1890 to 1891 Constitutional Convention complained that malapportionment existed under the charter also. At that convention, rural and urban delegates fought over the language of Section 33, with delegates from Louisville especially complaining that their city was underrepresented in the General Assembly and asserting that equal representation should be mandated in the new Constitution. Rural delegates sponsored the language that prevented more than 2 counties from forming a single representative district, but urban delegates succeeded in adding the somewhat inconsistent proviso that sought to ensure that 2 county districts would not violate the principle requiring every district to be as nearly equal in population as may be. Until the time of the landmark U.S. Supreme Court decisions of Baker v. Carr, in 1962, and Reynolds v. Sims, in 1964, which required representation to both houses of state legislatures to adhere to a one-person, one-vote standard, the Kentucky General Assembly ignored the requirements in Section 33 that nearly equal reapportionment should occur every 10 years. Reapportionment occurred less often and produced grossly unequal representation, which favored the dominant Democratic Party and rural areas. Although the Kentucky Court of Appeals held 2 of these reapportionments unconstitutional under Section 33, it never issued an order compelling the General Assembly to make representation nearly equal. The General Assembly has reapportioned districts in compliance with the U.S. Supreme Court rulings, but not always in a way that satisfied the Kentucky Supreme Court's interpretation of Section 33. In Fisher v. State Board of Elections, in 1994, the court held that the 1991 Legislative Reapportionment Act violated the prohibition in Section 33 against a division of counties between or among legislative districts. Further, a federal district court has held that the provision of Section 33 that prohibits the division of counties in apportioning representation violates the 14th Amendment of the U.S. Constitution inasmuch as the failure to divide results in unequal apportionment, in Upton v. Begley, 1971. A federal district court also held unconstitutional a reapportionment plan designed to preserve county lines wherever possible on grounds that the program resulted in too much population variation between legislative districts, in Hensley v. Wood, 1971.
Section 34. Officers of Houses of General Assembly. The House of Representatives shall choose its Speaker and other officers, and the Senate shall have power to choose its officers biennially. The language of this section appeared in 2 different sections of the Constitution of 1850. The Kentucky Court of Appeals cited Section 34 and its requirement that each house select its officers separately as one reason to invalidate a joint resolution of the General Assembly that authorized the hiring of a number of employees in excess of what was permitted by Section 249, in Shanks v. Julian, 1926. Section 35. Number of senators and representatives. The number of representatives shall be 100, and the number of senators 38. The first Constitution specified that there should be no fewer than 40 nor more than 100 representatives. In fact, the membership grew from 40 to 58 as population increased and new counties were created. The Constitution provided for 11 senators, with 1 to be added for every 4 new representatives, which meant that eventually there were 15 senators. The second Constitution provided for a minimum of 58 and a maximum of 100 representatives, a number that was eventually achieved with population growth and the creation of new counties. In like manner, membership of the Senate could increase from 24 to 38, the number that was ultimately achieved. The third Constitution provided for 100 representatives and 38 senators. Some delegates to the Constitutional Convention of 1890 to 1891 sought to reduce the membership of both houses in an effort to diminish governmental expenses and the number of governmental employees, but delegates from the smaller counties and rural areas defeated this effort because they feared a reduction would enhance the power of lawyer legislators and the urban areas. The Kentucky Court of Appeals, following a legislative redistricting, will not certify a district election for the state Senate where such an election will result in an increase of the number of senators in excess of that provided for in Section 35, in Angeles v. Land, 1963. Section 36. Time and place of meetings of General Assembly. 1. The General Assembly, in odd-numbered years, shall meet in regular session for a period not to exceed a total of 30 legislative days divided as follows. The General Assembly shall convene for the first part of the session on the first Tuesday after the first Monday in January in odd-numbered years for the purposes of electing legislative leaders, adopting rules of procedure, organizing committees, and introducing and considering legislation. The General Assembly shall then adjourn. The General Assembly shall convene for the second part of the session on the first Tuesday in February of that year. Any legislation introduced but not enacted in the first part of the session shall be carried over into the second part of the session. In any part of the session in an odd-numbered year, no bill raising revenue or appropriating funds shall become a law unless it shall be agreed to by 3/5 of all the members elected to each house. 2. The General Assembly shall then adjourn until the first Tuesday after the first Monday in January of the following even-numbered years, at which time the General Assembly shall convene in regular session. 3. All sessions shall be held at the seat of government, except in case of war, insurrection or pestilence, when it may, by proclamation of the governor, assemble for the time being, elsewhere. The current Section 36 was ratified as an amendment in November of 2000. In 1998, voters rejected a proposed amendment to Section 36, which would have reduced the organizational session held in odd-numbered years from 10 to 5 days and authorized an interim legislative session of not more than 25 days to be convened on the first Tuesday in February in odd-numbered years.
Section 37. Majority constitutes quorum, powers of less than a quorum. Not less than a majority of the members of each house of the General Assembly shall constitute a quorum to do business, but a smaller number may adjourn from day to day, and shall be authorized by law to compel the attendance of absent members in such manner and under such penalties as may be prescribed by law. Provisions very similar to this section can be found in each of the 3 other Kentucky constitutions. There have been no published judicial decisions about this section, but the Attorney General has issued 2 opinions. One declaring that a majority of each house of the General Assembly must be present in order for the Assembly to respond to a call for a special session, and the other that the senatorial quorum is 20, regardless of vacancies. Section 38. Each house to judge qualifications, elections, and returns of its members, contests. Each house of the General Assembly shall judge of the qualifications, elections, and returns of its members, but a contested election shall be determined in such manner as shall be directed by law. This section guarantees a basic legislative right that was only incompletely achieved during the colonial period of American history. The identical language appeared in the second and third constitutions. The first constitution omitted elections and returns of its members and provided that a committee would decide contested elections as shall be directed by law. Pursuant to this section, the General Assembly has created a statutory process to contest elections. The Kentucky Court of Appeals has held that a resolution by the Senate recognizing a member as duly qualified precludes the court from deciding otherwise, even if, arguably, the member, by accepting appointment to an incompatible office, had forfeited the office of senator, in Rainey v. Stovall, 1962, and that the House or Senate may pay, out of the public treasury, the costs of a contested election to their body, including attorney's fees of the parties to the contest, in Mercer v. Coleman, 1929. Section 39. Powers of each house as to rules and conduct of members, contempt, bribery. Each house of the General Assembly may determine the rules of its proceedings, punish a member for disorderly behavior, and, with the concurrence of 2/3, expel a member. But not a second time for the same cause, and may punish for contempt any person who refuses to attend as a witness, or to bring any paper proper to be used as evidence before the General Assembly, or either house thereof, or a committee of either, or to testify concerning any matter which may be a proper subject of inquiry by the General Assembly, or offers, or gives a bribe to a member of the General Assembly, or attempts by other corrupt means or device to control or influence a member to cast his vote or withhold the same. The punishment and mode of proceeding for contempt in such cases shall be prescribed by law, but the term of imprisonment in any such case shall not extend beyond the session of the General Assembly. The first 3 clauses of this section appeared in the first 3 constitutions, with the current charter adding language about punishing for contempt or bribery. The added language reflected the rise of the legislative hearing and the need of those hearings to compel testimony and produce documents, and also the desire to curtail unlawful efforts to influence legislators, which was perceived to be a growing practice, especially on the part of railroads and other corporations. Pursuant to this section, the General Assembly has enacted laws punishing contempt of the legislature, breach of legislative privilege, disobedient witnesses, attempts to corrupt a legislator, and the giving and taking of bribes. There have been very few published decisions concerning this section. In one of the most important, Campbell v. Commonwealth, in 1929, the Kentucky Court of Appeals ruled that the section did not prevent the General Assembly from making corrupt lobbying a criminal offense punishable by the courts.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.